Phoenix, 2024. The trust the family signed protected nothing. The papers were notarized. The deed was retitled. The family thought $400,000 in home equity was safe. Medicaid counted every dollar. The autopsy shows the family had bought the wrong kind of trust. The lawyer never explained there were two kinds. This pattern repeats in most cases we've reviewed. Karen and Tom lived in Phoenix in a brick ranch with a backyard their grandkids called the desert. In 2016, they visited a respected family attorney. 20 years on his card, 3 Yelp reviews on his door. He drafted them a revocable living trust. They moved the house, the savings, the lake cabin deed. He told them this would protect them. He was right about probate. He was wrong about Medicaid. 8 years passed. Karen developed early-onset Alzheimer's at 63. She needed memory care nursing within a year. The cost in Arizona was $12,000 per month. Tom applied for Medicaid in March 2024. He thought it would be straightforward. The lawyer had assured them 8 years earlier that everything was protected. The trust binder sat unopened on the kitchen counter for the entire 11-minute interview. The Medicaid officer barely opened it. The application asked one question that ended the plan. List every asset, including assets held in revocable trust. Their home was in a revocable trust. Revocable trusts are countable assets in every state. Medicaid valued the home at $400,000. The application was denied on the first review. Tom called the original attorney. The attorney said, "A trust is a trust to most clients." The family had paid him $12,000. The trust did exactly what it was sold to do, and nothing the family actually needed. There are two trust families: revocable, irrevocable. Revocable means you can pull assets back. Medicaid sees that as ownership. If you can reach it, they can count it. Irrevocable means you handed control to a trustee, and you cannot take it back. If you cannot reach it, neither can Medicaid. Most family lawyers draft revocable trusts by default. They are profitable, common, and answer the question every client asks first. What about probate? Probate is loud. Medicaid is quiet. Families request what they hear about. Most families we examine believe the same 3 myths about trusts. Myth 1. A trust protects assets from Medicaid. Most trusts do not. Only one specific structure does. Myth 2. Revocable just means flexible. Revocable means you still own it. Owned means countable. Myth 3. Setting up early enough makes any trust safe. Timing protects against the lookback. Structure protects against everything else. A trust survives Medicaid review when 3 conditions are met. First, the trust is irrevocable. The grantor cannot dissolve it or pull assets back out. Second, the trust transfers happened at least 60 months before the application. This clears the federal lookback window. Third, the trust is drafted as a Medicaid asset protection trust specifically. Generic irrevocable trusts can still trigger gift tax penalties. 3 conditions. Stack them and the trust holds. Miss any one and the trust fails. The cases agree on this. In the files we've opened, 4 patterns separate trusts that work from trusts that fail. Pattern 1. The lawyer who draws 10 or more Medicaid trusts every year. Volume produces structural fluency. Pattern 2. The trust funded with the home, not just listed by reference. Title transfer is the act that begins the look-back clock. Reference-only filings fail when state Medicaid offices ask for recorded title. Pattern 3. The trust that names a third-party trustee, not a child. Children as trustees triggered review questions in over half the cases we examined. Pattern 4. The trust reviewed annually for federal rule changes. Medicaid rules shift quietly. The 2024 California rule change caught dozens of unreviewed trusts overnight. Which state is your trust drafted under? Because the answer changes everything. State law shapes what a Medicaid trust can hold. California eliminated the Medi-Cal asset test in January 2024. The lookback rule still applies to all transfers. Florida pursues estate recovery aggressively, including post-death liens on trust homes. Texas allows broader homestead protection for primary residences in trust. The lookback rule still counts the transfer. New York runs separate community Medicaid and institutional Medicaid rule sets. Trusts must be drafted to satisfy both regimes simultaneously. Some families ask, what about the families who already signed the wrong trust? The cases we've reviewed show 3 legitimate options. 1. Convert the revocable trust to an irrevocable one before any diagnosis. The look-back clock restarts, 60 months from the conversion date. 2. Spousal transfer. A community spouse keeps a separate resource allowance. That allowance protects part of the assets in nearly every state. 3. In elderly cases, the home itself may remain exempt during the recipient's lifetime. Most state Medicaid programs allow this while a spouse still lives there. These are narrow doors. They exist, but every one of them closes the day a diagnosis arrives. The Council's note. This is not legal advice. Laws vary by state. We examine cases. You make the call with your attorney. Compare Karen and Tom's file to a file from Tampa, 2024. Janet and Ray transferred their home into an irrevocable trust in 2017. They were 61 and 63, healthy. Their attorney was a certified elder law attorney with 30 years in Medicaid filings. He drafted a Medicaid asset protection trust, not a revocable trust. Ray had a stroke in 2024, 7 years after the transfer. Janet applied for Florida Medicaid that summer. The trust transfer was 84 months in the past, 24 months outside the lookback window. Medicaid approved the application on the first review. The home stayed in the trust. The family kept the equity. $380,000 protected. Same disease as Karen. Same federal rule. Different trust. Different outcome. One more pattern from the cases. 3 actions repeat in the cases that ended with approved Medicaid applications. First, families confirmed the trust was irrevocable in plain writing before signing. Verbal assurances do not survive a Medicaid review. Second, families verified the trust was drafted by a certified elder law attorney. CELA certification is the only nationally recognized credential for this work. Third, families dated and archived every trust document and transfer record. Medicaid asks for 60 months of records. Memory does not survive that audit. The full pre-autopsy checklist, every item we've seen separate trusts that work from trusts that fail, is at haircouncil.com/checklist. linked in the description. One more pattern from the autopsies. The families who waited until the diagnosis came in had no path left. By the time someone needs nursing care, the trust drafting window is closed. Medicaid does not care that the family meant well. Only the timestamp and the structure of the trust. And neither one waits. Next on the Council's review desk, how to vet a Medicaid attorney and the 5 questions most families forget to ask. The file closes. Yours doesn't have to open the same way. Subscribe before the next case opens.